how are administrative law or administrative court decisions challenged by a party? To start with, the party challenging the administrative court's decision has to have standing. They have to be affected in some way directly by the administrative court's decision. Now, before a court will ever review an administrative court's decision, the party filing an action with the court must have exhausted all administrative remedies. Now, what this means is they had to go through the process of appealing or asking for review of the administrative court's decision, and that request has to have been acted on to its final extent. Now, there are limited situations there where the process will be futile or there's an exigency issue in place. Once it's demonstrated that they have standing and that they've exhausted all of their administrative remedies, it would have to be shown that the issue is right for review, that there's still not an issue as to the authority of the administrative agency with regard to how this action is carried out and for what reasons there are behind it. If there are any issues there, then the proceeding will be stayed until the administrative action is worked out and the delegation of authority and justification behind that is worked out. Now, if all this is ready for review, the trial court will take the record of trial from the administrative agency and begin to review it for failure to follow administrative procedure and any level of arbitrary or capricious action by the administrative agency. That is, actions that are not consistent with the underlying stat of variance from the authority vested or procedure in place for handling this type of activities. Generally, you're looking for arbitrary and capricious action by the administrative court. And if you find this, again, the trial court can ask for clarification, can accept additional information or evidence, and can even overturn the administrative action if it finds that action to violate the individual's due process rights and in that way to be unconstitutional. In that situation, again, the trial court is acting somewhat like an appellate body in that it is taking the record of the administrative trial, accepting the evidence that has substantial justification or substantial support along with it. Again, there's this de novo type of review that is that the trial court can still accept additional information for making this determination and reviewing for any arbitrary or capricious action by the court.